Good day. This is the Child Care and Development Fund, CCDF Plan Section 2B, Comprehensive Background Checks PowerPoint for tribal lead agencies of all allocation sizes. We want to welcome you and thank you for joining today's session. We'll be discussing the comprehensive background check requirements, including alternative approaches and flexibilities for tribal lead agencies and how to navigate Section 2B of the Tribal CCDF Plan. Today, we will review all things background checks. We hope you walk away with an understanding of the comprehensive background check requirements and flexibilities, including who the background checks apply to and what the minimum required checks are. Also, an understanding of the flexibility to propose alternative approaches, including identifying which requirements are eligible to have an alternative approach and which are not, and the criteria OCC uses to evaluate and approve alternative approaches. And also an understanding of what sufficient responses are for Section 2B. And lastly, we hope you are able to build an awareness of your implementation status of the comprehensive background check requirements. Let's start with the basics. To understand what background checks are required and who they apply to. Throughout the presentation, we will use three different terms that have distinct and important differences. Requirements come from the law, the Child Care and Development Block, or CCDBG Act, and the Tribal Child Care and Development Fund, CCDF regulations. Tribal lead agencies are subject to all comprehensive background check requirements, regardless of allocation size. Flexibilities are options for all tribal lead agencies, including states and territories. These are built into the law and regulations and are separate from an alternative approach. Implementing a policy that is a flexibility under CCDF does not require additional justification by the tribal lead agency or approval by OCC. Alternative approaches are an additional option to implementing comprehensive background check requirements that are only available to tribal lead agencies. Alternative approaches require the tribal lead agency to provide justification as to how the alternative approach ensures that all children in childcare settings remain safe. Additionally, OCC must approve a tribe's alternative approach, and just because a tribe proposes an alternative approach does not mean it will be approved. So, who is required to have a comprehensive background check? All of the background checks are required for all child care providers who serve CCDF-funded children, including providers who are regulated by your tribal CCDF program. This includes all staff, contracted employees, and volunteers with unsupervised access to children, as well as adults living in family child care homes. This essentially covers any individual who is employed by the child care provider and any individual who may have unsupervised access to children in care. Tribal lead agencies have the flexibility to exempt all, some, or none of the background check requirements for providers who meet the CCDF definition of a relative provider, which is defined as grandparents, great-grandparents, aunts, and uncles. Siblings can also be considered a relative if they live in a separate residence from the child or children in care and are age 18 and over. Tribes may fully exempt relative providers from background checks if the provider only cares for children they are related to in a home-based setting. This flexibility often gets confused with the alternative approach for adult household members. The key difference is relative providers can be fully exempt if the tribe chooses. On the other hand, household members, adults living in a family child care home, must still undergo some form of background check, though an alternative approach can be proposed for those checks are conducted. So while relative providers can be exempt entirely, adult household members in a family child care home must still be checked. The only flexibility there is in how the check is done. CCDF comprehensive background checks must include 3 in-state checks: criminal history registry check with fingerprints, sex offender registry check, and child abuse and neglect registry check. 2 national checks: the FBI fingerprint check, the National Crime Information Center National Sex Offender or NCIC NSOR name-based check, and 3 interstate checks, but only if the individual lived in another state in the preceding 5 years. This totals up to 8 background checks in all. The background check components must be completed at least once every 5 years. Tribes can propose alternative approaches if access to any of these checks is unavailable, and we will cover this portion in more detail soon. The Office of Child Care recognizes tribal nations face unique challenges in accessing the Child Care and Development Fund Block Grant, CCDBG, required background checks. This is because tribes are not authorized to conduct the FBI fingerprint check under CCDBG, and tribes are not authorized to conduct the NCIC INSOR check under CCDBG. This means that unlike state and territory lead agencies, the Act does not provide tribes the authority to access these 2 checks for CCDF purposes, yet they are still required. Some tribes also face state-level barriers to assessing background checks. To address these challenges, some tribes developed partnerships or learned how to navigate various systems in order to access some or all of the required checks, while others have proposed alternative approaches for meeting the intent of comprehensive background checks. Next, we will discuss the variety of approaches tribes are currently using. Carrie?
Thank you, Paula. The first optional approach we'd like to highlight is having a state agency or system conduct one or more of the required background checks on behalf of the tribal lead agency. Tribes can work with states to develop a partnership to conduct the checks, or a tribe may be paying a state-regulated CCDF child care provider. Therefore, the provider is receiving the required checks because of their affiliation with the state CCDF child care licensing system. If this approach is one your program uses, your selections in section 2.9 to indicate this will trigger the skip patterns in CARS. Some tribes may also have direct access to a state's registry, or may use a state's access to a national registry to conduct checks independently. However, states use different laws to authorize state registry checks and national checks, and not all states allow tribes to participate. If state partnership or access isn't an option, a tribe may propose an alternative approach to any of these required background checks. Or in other words, a tribe has the flexibility to propose an alternative to the background checks required by law. The last optional approach is an official alternative approach proposal. If a tribe attempts to work with the state but is unsuccessful, they may propose an alternative for any of the 8 background check components. However, OCC will not approve approaches that bypass the intent of the law. The goal is always to protect children's safety while acknowledging tribal jurisdiction challenges. We also want to emphasize that if a tribe has authority, access, and the ability to conduct a check but chooses not to complete it, OCC will not consider this an approvable alternative approach. If a tribe has the ability to access a check, conduct a check, or request a check, the tribe is expected to complete the check to meet the requirements of the law. As a reminder, we already covered that the CCDBG Act does not explicitly give tribes the authority to conduct the FBI fingerprint and NCIC INSOR name-based checks. In addition, some states don't grant access to their state registries or repositories. For these reasons, there is an alternative approach flexibility for tribal nations included in the CCDF regulations. But there are certain criteria that must be met in order to have an alternative approach approved by the Office of Child Care. So what is that criteria? First, tribes must have made an attempt to access the required check. That can mean reaching out to the state, requesting access to a state registry, or exploring state partnerships. If those efforts didn't work, tribes must document this in section 2.17 of the plan. If the required check isn't possible, the alternative approach must still make an effort to verify an individual's criminal, child abuse, and sex offender history. Lastly, in section 2.17, you will describe how your overall approach is comprehensive and protects the health and safety of children. The goal of the CCDF requirement is protecting the health, safety, and well-being of children in child care. For that reason, OCC cannot approve alternative approaches that weaken safety measures for children. Now that we discussed the criteria, let's review some considerations. Like we shared on the previous slide, tribal lead agencies must make an effort to verify an individual's history concerning one, two, child abuse, and three, sex offender history of an individual. Some examples of this could look like at least one check of any available criminal registry, example, the FBI fingerprint check, state criminal registry, or tribal criminal registry or records. At least one check of any available sex offender registry, like the national, state, online, or tribal sex offender registry or records, and at least one check of a child abuse and state or tribal child abuse neglect registry or records. OCC encourages using available resources such as state registries, national registries, third-party vendors, or tribal databases. So far, we've covered where an alternative approach may be appropriate concerning conducting the 8 required checks. Later in this session, we will cover other components of the background check requirements that may also include an alternative approach. Now let's dive a bit deeper into the structure of the CCDF plan in section 2.9 through 2.17. Paula?
Thank you. Now let's take a closer look at plan selection options in the plan for section 2.9, in-state criminal history checks. Tribal lead agencies have several options when completing this check. Here's what that looks like in practice. Pre-approved approaches, including using the state criminal registry or partnering with a state agency to conduct the check. If neither of those are an option, alternative approaches may include, but are not limited to, using a third-party vendor, tribal database, or another alternative method. Each option has different costs, processing times, and access considerations. Tribes should weigh which options are possible based on their resources. Now let's shift gears to the in-state sex offender registry check. A state's public or non-public sex offender registry is the most straightforward way to meet this requirement. However, if a state does not grant access to their registry, tribes may need to propose an alternative approach, which could include using a tribal sex offender registry, if available, or contracting with a third-party vendor. The tribe should select other if the proposed alternative approach is something other than what is listed here. Last in this category is the child abuse and neglect CAN registry check. Like the previous checks, there are 2 pre-approved methods, working with the state or accessing the state's CAN registry directly. If neither of those options are available, alternative approaches may be proposed. If a state will not provide access to their CAN registry, some tribes may be able to verify a provider's history through tribal child welfare records, work with a third-party vendor, or collaborate with neighboring jurisdictions. The key across all 3 in-state checks, you need to have a clear process in place that meets the intent of the regulation, even if the exact method differs from what's outlined in federal law. FBI fingerprint checks are one of the more comprehensive options for accessing a person's criminal history, but not every tribe has access. The CCDBG Act does not provide tribes with direct authority to conduct FBI fingerprint checks. However, tribes can partner with states or use the Indian Child Protection and Family Violence Prevention Act as an authorizing statute. This authorizing statute allows tribes to conduct FBI fingerprint checks through the Department of Justice Tribal Access Program, FBI-approved channelers, or through hard copy fingerprint cards mailed to the FBI. The key takeaway here is that tribes have both the authority and the obligation to conduct FBI fingerprint checks for employees in tribally operated centers under the Indian Child Protection and Family Violence Prevention Act. Because of this, skipping the check would not be an approvable alternative approach. However, if conducting the check is truly not possible due to circumstances beyond the tribe's control, that's when an alternative approach may be considered. Alternative approaches can include name-based criminal checks using tribe or state registries or third-party vendors. Tribal Access Program, or TAP for short, is a program that tribes can apply to through the Department of Justice. TAP provides tribes with direct access to conduct the fingerprint check for employees of tribally operated centers only. TAP does not cover FBI fingerprint checks for family child care providers or in-home child care providers. An FBI-approved channeler is a private business that has contracted with the FBI to electronically submit fingerprints to the FBI consistent with FBI submission procedures. Hard copy cards mailed to the FBI are another option. Tribes may submit hard copy fingerprint cards directly to the FBI through the U.S. mail. The National Crime Information Center, NCIC, National Sex Offender Registry, NSOR, name-based check is another area where tribes face barriers to access. Tribes do not have statutory authority to access the NCIC NSOR name-based check under the CCDBG Act. However, tribes may propose an alternative approach to determine an individual's sex offender history. Options include using public sex offender registries like the National Sex Offender Public Website, nsopw.gov, state sex offender registries, tribal sex offender registries, third-party vendor checks, and FBI fingerprint checks, which include NSOR results. The bottom line is some effort must always be made to check a provider's sex offender status. Carrie?
Thank you, Paula. So as you begin to think about how to meet the requirement to conduct the name-based check of the NCIC NSOR, it is important to note that name-based records in the NCIC NSOR are only available to law enforcement agencies. FBI channelers, and private third-party companies and vendors do not have access to the name-based records within the NCIC NSOR database. Now that we discussed the background checks that are required for childcare staff, let's talk about how to complete, interpret, and administer the required background check components. In home-based childcare settings, background checks aren't just for the provider. They also apply to any adults living in the family childcare home. But what happens if fingerprinting isn't possible for a household member? Some possible alternative approaches could include using name-based criminal history checks instead of fingerprints, or verifying tribal or state welfare records to ensure no prior abuse or neglect concerns. There are some additional examples on this slide for your reference. The goal is to ensure anyone with access to children is screened appropriately, even if comprehensive background check with all 8 components is not an option. The Child Care and Development Block Grant Act prevents individuals who have been convicted of certain crimes from being employed by a child care provider. In addition to the felony and misdemeanor convictions shown on the slide, any individual who is registered or required to register as a sex offender or who has refused or made false statements in connection with the comprehensive background check is unable to be employed by a child care provider. A list of disqualifying crimes for reference. The disqualification criteria includes refuses a background check, knowingly makes a materially false statement in connection with the background check, is registered or is required to be registered on the state or national sex offender registry, has been convicted of a felony consisting of murder, child abuse or neglect, crimes against children, spousal abuse, crime involving rape or sexual assault, kidnapping, or arson. Physical assault or drug-related offenses committed during the preceding 5 years, or has been convicted of a violent misdemeanor committed as an adult against a child. Examples of crimes against children. FBI's Violent Crimes Against Children program describes crimes against children as child abductions, which are the mysterious disappearance of a minor, especially if a minor of tender years, which is 12 years or younger. Contact offenses against children, which is the production of child sexual abuse material. Sextortion, which is a crime that involves adults coercing kids and teens into sending explicit images online. Domestic travel to engage in sexual activity with children, and international travel to engage in sexual activity with children. Sexual exploitation of children, which is online networks and enterprises manufacturing, trading, distributing, or selling child abuse material. Trafficking of child sexual abuse material, which is distribution or possession. International parental kidnapping, wrongfully retaining a child outside the United States with the intent to obstruct the lawful exercise of parental rights. Another area where tribes may need flexibility is in handling disqualifying crimes. While certain offenses, especially crimes against children, are lifetime bans from child care employment and can never be waived, other offenses may require a different approach. Instead of a lifetime ban from child care employment, possible alternative approaches could include establishing an individualized review process for the disqualifying crimes, considering rehabilitation factors such as time passed since the offense and completion of rehabilitation programs, creating a review board that assesses eligibility based on tribal values and safety considerations. OCC will not approve an approach that removes the lifetime ban for individuals convicted of crimes against children. However, tribes may propose a process for reviewing other offenses on a case-by-case basis. The law provides flexibility for tribal lead agencies in regard to individuals disqualified due to felony drug offense. The tribal lead agency at its option may allow for a review process through which the tribal lead agency may determine an individual still eligible for employment. Under CCDF regulations, tribal lead agencies may conduct an individualized review of drug-related felony convictions from the past 5 years before deciding whether to disqualify a prospective staff member. This flexibility allows tribes to evaluate each case based on additional factors such as rehabilitation efforts and time elapsed since the conviction and evidence of behavioral change. Because this review process is already a part of the law, it is not considered an alternative approach. This means that a drug-related conviction does not have to result in a lifetime ban, and tribes have the choice to assess the situation on a case-by-case basis with the parameters set by CCDF regulations. I want to clarify that the alternative approach for disqualifying crimes, just as discussed earlier, is different because it allows tribes to propose an individualized review process for other crimes outside of the specific drug-related offense flexibility. Additionally, tribal agencies can go further by adding their own disqualifying crimes such as financial fraud or animal cruelty if they believe these offenses couldn't impact a person's ability to care for children. This is often confused with the alternative approach for disqualifying crimes, which allows tribes to reduce lifetime bans on certain offenses. But the key difference is that this flexibility allows tribes to be more strict, adding additional crimes to their disqualification list. And an alternative approach would allow tribes to be less strict, modifying the lifetime disqualification for certain offenses. So this flexibility lets tribes add more restrictions, while an alternative approach would let them ease certain restrictions. So if a tribe is using one of these existing flexibilities, there's no need for an alternative approach because these options are already a part of the law. But if a tribe wants to go beyond what's already written into CCDF regulations, that's when an alternative approach is required. Paula?
Okay. Tribal lead agencies have the flexibility to charge fees for completion of the background check process. Fees may not exceed the actual costs of processing applications or administering the comprehensive background check. OCC will not approve an alternative approach that allows the tribal lead agency to charge a fee beyond the cost of administering the background checks. Now we will discuss the 45-day requirement. CCDF regulations require that background checks be completed within 45 days, but in reality, that timeline isn't always possible, especially if a state is slow to respond, fingerprinting is backlogged, or interstate checks take longer than expected. If a tribe is facing delays beyond its control, they may propose an alternative approach that extends the processing timeline, such as allowing 60 days instead of the required 45 days. The key here is to demonstrate that the delays are beyond the tribe's control and to ensure the child's safety remains the priority while background checks are still being processed. While CCDF regulations require background checks to be completed within 45 days, OCC recognizes that delays can happen, especially for interstate checks that require coordination between multiple agencies. If background checks take longer than 45 days, tribal lead agencies have the flexibility to make employment decisions based on available information rather than waiting indefinitely. This flexibility means that tribes can proceed with employment decisions even if some background check components are delayed, and the example shown on this slide would not require an alternative approach. However, an alternative approach would be needed if a tribe wants to extend the 45-day requirement entirely. For example, by adopting a policy that allows checks to take 60 or 90 days before an employment decision is made. Tribes have the option to implement a provisional hire policy that allows a child care staff member or child care provider to begin work prior to receiving the full results of their comprehensive background check. If a tribe chooses to allow provisional hires, certain rules apply. The CCDF regulations require that the individual may begin working after passing either the FBI fingerprint check or the state fingerprint check. The provisional hire must be supervised at all times by someone who has passed a comprehensive background check within the past 5 years. This flexibility allows a tribe to choose whether or not to have a provisional hire policy. But if a tribe wants to change the requirements of provisional hiring, such as allowing a provisional hire to start working before fingerprint results come in, or altering the supervision component, that would require an alternative approach. Again, tribes can opt out of having a provisional hire policy altogether and require all checks to be completed before an individual can be hired. Provisional hiring allows staff to begin working while waiting for background check results, but only under certain conditions. OCC may approve alternative approaches for fingerprinting if it is not possible for a tribe to complete an FBI fingerprint check or an in-state criminal fingerprint check for a provisional hire. In these cases, tribes must first attempt to partner with the state to conduct fingerprint checks. If those efforts are unsuccessful, a name-based state or tribal criminal registry check or another approved method may be proposed. However, tribes operating tribally run child care centers must conduct FBI fingerprint checks for tribal employees, since they have the authority to do so under the Indian Child Protection and Family Violence Prevention Act. Alternative approaches are only an option when fingerprinting is truly not possible, and tribes will be required to discuss the barriers for conducting this check in the CCDF plan. Now let's look at another type of alternative approach. This involves adjusting when a provisional hire may begin working. Tribes may propose allowing staff to begin working after submitting a background check request, even if results are still pending. For example, if an individual has submitted their fingerprints for an FBI fingerprint check, but has not yet received results, an alternative approach may allow them to begin work before the results are finalized, as long as safeguards are in place. Any alternative approach in this area must prioritize child safety, ensuring that proper oversight and risk management measures are in place until all background check results are received. Carrie?
Thank you, Paula. Tribal lead agencies must determine a child care staff member's eligibility for employment while ensuring privacy protections are maintained. According to the CCDBG Act, a background check results provided to child care providers must state only whether a staff member is eligible or ineligible for employment, without disclosing specific details about criminal history or disqualifying offenses. However, tribes may propose an alternative approach that allows for sharing some additional information, but this must comply with FBI policy and state or tribal laws, which may restrict the release of sensitive data. Please remember that privacy is especially important in small tribal communities where disclosing background check details could impact personal and professional relationships. Any proposed alternative approach must carefully consider these privacy concerns. Ultimately, background check determinations must balance transparency with confidentiality, ensuring employers receive necessary information without compromising individual privacy. OCC will not approve any alternative approaches to the appeals process, and all tribal lead agencies must meet the CCDF requirements related to background check appeals. Question 2.16 in the CCDF plan will ask tribal lead agencies to certify that they meet each of the requirements for the background check appeals process. All tribal lead agencies must provide information to the individual in writing that notifies them of the results of their comprehensive background check and includes a notice of the ability to file an appeal. Tribal lead agencies must also provide written notice that includes clear instructions about how to complete the appeals process for each background check component if the individual wishes to challenge the accuracy or completeness of the information contained in the individual's background check. Once an appeal has been filed, tribal lead agencies must attempt to verify the accuracy of information challenged by the individual, which includes making an attempt to locate any missing disposition information, such as a final verdict or dismissal of charges related to the disqualifying crime. Tribal lead agencies must ensure that any appeals are completed in a timely manner. OCC does not define what is considered timely, however, encourages tribal lead agencies to complete any appeals within 90 days of the appeal being submitted. Once a final determination has been made on the individual's appeal, the tribal lead agency must notify the individual in writing and include a description of how the tribal lead agency attempted to verify any information challenged by the individual, any additional appeal rights, and how an individual can correct records that are at issue in the appeal. Now that we know how to propose an alternative approach, we will discuss how to get an alternative approach approved. An alternative approach must include two components to be considered for OCC approval, and they are a justification for the alternative approach and an explanation as to how the alternative approach is comprehensive and ensures the health and safety of children in care. Again, as a reminder, each alternative approach is subject to OCC approval, and OCC will not approve approaches with blanket exemptions or waivers that bypass the intent of protecting children's safety. For each alternative approach, tribes must indicate the issues or barriers preventing the tribal lead agency from conducting the required checks. Each option describes a reason that impacts the tribe's ability to conduct the required checks. The tribal lead agency must select all that apply. As a reminder, if a tribe has authority, access, and ability to conduct a required background check but chooses not to complete it, OCC will not consider this to be an approvable alternative approach. If a check can be conducted, it must be conducted. While there is flexibility in proposing alternative approaches, there are also clear non-negotiables, things that OCC will not approve under any circumstances. These are absolute rules designated to protect children's safety, maintain the integrity of background checks, and ensure compliance with CCDF regulations. OCC will not approve alternative approaches that allows the hiring of individuals convicted of crimes against children. If a person has been convicted of any crimes against children, they cannot work in a CCDF-funded child care setting. This is a federal requirement with no exemptions. Even if a tribe has an individualized review process for other types of convictions, these offenses are an automatic disqualification. OCC will not approve alternative approaches that charge excessive background check fees. Background check costs should not create a financial barrier for child care staff members, and fees should not exceed the actual cost of processing a background check. OCC will not approve alternative approaches that extends checks beyond the 5-year requirement. All background checks must be renewed at least once every 5 years. A tribe may choose to require checks to be done more frequently than 5 years, but a 5-year renewal period is the minimum interval required under CCDF regulations. Additional circumstances that OCC will not approve an alternative approach involve: OCC will not approve alternative approaches that eliminate due process or appeals. An appeals process is an important aspect of ensuring due process for staff members and allows them to challenge the accuracy of background check results. OCC will also not approve alternative approaches that alter the definition of who must be checked. All staff, contractors, and volunteers with unsupervised access to children, as well as adults living in family child care homes, must undergo background checks. OCC will not approve any alternative approach that tries to redefine or narrow the group of individuals subject to these checks. OCC will not approve alternative approaches that waive FBI fingerprint checks for tribal employees who are subject. If a tribe has the statutory authority to conduct FBI fingerprint checks, those checks must be conducted for tribal employees. The bottom line is alternative approaches exist to provide flexibility, but if an alternative approach weakens child safety protections, it is less likely to be approved. The goal is to help tribes navigate barriers without compromising on security or compliance. So to wrap up, we want to emphasize that tribes are expected to comply with background check requirements to the best of their ability. The goal is to make these checks as thorough and comprehensive as possible to ensure the safety of children in care. Tribes can demonstrate their commitment by making a good faith effort to verify criminal history, child abuse and neglect history, and sex offender status for all prospective and current child care staff. One important reminder, if a tribe has the authority, access, and ability to conduct a required background check but chooses not to complete it, OCC will not consider this to be an approvable alternative approach. Again, if a check can be conducted, it must be conducted. And ultimately, the goal is to use every available tool to create a safe and secure environment for children while also recognizing and addressing any barriers that may exist. And I'll pass it to Paula to wrap things up.
Thank you, Carrie. Before we wrap up, let's review the most important points to remember about alternative approaches to background checks. Alternative approaches exist to help tribes comply when standard checks are not possible. Some background check components allow flexibility, but others do not. Child safety must always come first. And I'll repeat, if you listen to the slide presentation, child safety must always come first. Justification and a comprehensive alternative are required for OCC approval. I hope this presentation has helped clarify when and how alternative approaches can be used. Lastly, I'd like to share how to connect with how you can connect with us. If you are not already, please do subscribe to the OCC announcements to receive all of the latest information. You can visit the website for the various resources mentioned today. Feel free to email occtribal@acf.hhs.gov if you would like to connect directly. Thank you for all your time and participation today.